years ago, it was difficult to get spousal maintenance, even if you had been a stay-at-home parent or a homemaker during that time. The court wasn't giving out permanent awards of spousal maintenance quite as easily as the next phase. And then there was a case that changed that, and it codified both in case law and in the statute that a homemaker's contribution to income and the marital estate was equal to the breadwinner's. And so the argument that that spouse stayed home and ate bonbons didn't fly anymore. They could have stayed home and ate bonbons, but they were still considered to have had a substantial contribution to the accumulation of assets. And that has been the way it's been for quite a long time. But about 5 years ago, there seemed to be a shift, and there were a couple of cases that supported this idea that even if you've been a stay-at-home spouse or a homemaker spouse, or even if you were 55, you had an obligation to contribute to your support as well as the support of any minor children. And so nowadays, I think everybody would say that there's an expectation, even if you've been stay-at-home, that you're going to have either income attributed to you or you're going to have a job. A few exceptions. If your health doesn't allow you to work, that's an exception. If you have a child that requires care so that you need to be at home, that's an exception. Every once in a while, the judges will think that if you have children that aren't in school yet, they may give you an exception for a year or two to get all the kids in school. But those are the exceptions, and so anybody looking for spousal maintenance nowadays has to assume that they're going to have to contribute themselves to their own support.